Hi, everyone. Thank you so much for joining us. My name is Lauren Sampson. I am a staff attorney at Lawyers for Civil Rights. I'm joined by my colleague, Jake Leibovic, our community outreach paralegal.
Hi, everyone.
And we're joined by the city of Somerville and our friends at the Welcome Project to talk a little bit about the public charge rule, which I know has gotten an enormous amount of press attention. And we wanted to take this opportunity to talk a bit about recent developments on the public charge rule, to clear up any information that might be out there, and to provide folks some relief, knowing that the rule, despite seeming very frightening, has a lot of exclusions, a lot of exemptions, and may not apply to you. So we want to give folks the information that they need to make the decisions that are right for them and for their family. So what exactly are we talking about? What is the public charge rule? The concept of public charge has existed in US immigration law for over a century. Historically, public charge referred to an individual who was primarily dependent on the government for their upkeep or care, defined usually as about 51%. So around 51% of your income comes from governmental sources. Historically as well, only a few key things were looked at when establishing whether someone was a public charge. For example, are you institutionalized long-term at the government's expense? Are you receiving certain kinds of cash benefits, for example, SSI or TANF? However, the Trump administration altered the meaning of the public charge regulation to be a bit more expansive. Now, the public charge rule is a multifactorial test that looks at a number of different factors, including the use of public benefits, age, English proficiency, work history, income and wealth, and education to determine if an individual is now or ever will be a public charge. The public charge rule doesn't just apply to anyone at any time. It's specific. It applies to certain applicants for legal permanent residency status from abroad, certain applications to adjust one's status to legal permanent residency, legal permanent residents who've been away from the US for 6 months or more and are now returning. And there is a related but kind of separate public benefits condition if you're looking to extend or change certain kinds of non-immigrant status. So that's really important. The public charge rule only comes into play if you are trying to get certain kinds of immigration relief from USCIS. It doesn't just apply if you happen to be an immigrant living in the United States. There has to be a particular trigger or interaction with USCIS to have the public charge rule be applied to you. In addition, the new public charge rule, the one I'm describing here, only came into effect on February 24th, 2020. Even though it was initially supposed to be published in the fall of 2019, there were a number of legal challenges that meant it didn't come into effect until that date. What that means is if you applied for legal permanent residency before that date, the old public charge rule, the one I was describing earlier, would apply to you, not the present one. The new public charge rule looks at a slightly larger list of benefits. So beyond the cash-based assistance that was already included, things like TANF, SSI, TAFDC, or EAADC, the public charge rule is now also looking at SNAP, or food stamps, Medicaid, Section 8 vouchers, and the use of federal public housing. Importantly, this is a multifactorial test. So the use of these public benefits does not mean you will automatically be considered a public charge. It's just a heavily weighted negative factor that could be outweighed by other positive factors. The public charge rule does not apply to many individuals and to many kinds of public benefits. Let's say, for example, you already have a green card and you're applying for citizenship to naturalize. You're filing the N-400. Those individuals do not have to worry about the public charge rule. It does not apply at that level. You do not have to file the requisite form in order to get citizenship from USCIS. So if that's something that you're doing, you don't need to worry about it. This is the form I-944. You don't need to file that if you're applying for citizenship. Let's say that you're re-registering for TPS, or you're re-registering for DACA. You do not have to worry about the public charge rule. It does not apply if you are re-registering for those statuses. Let's say also that you're a refugee or an asylum seeker, or you hold a visa under VAWA, the Violence Against Women Act, or you have a U or T visa, or you're a special immigrant juvenile, and you're trying to get legal permanent residency or apply for a green card, the public charge rule will not apply to you. Even though you are applying for legal permanent residency, and you may be applying through a family relationship or a work-based relationship, if you are currently in the status of refugee, asylum seeker, or one of those listed there, the public charge rule will not apply to you. There are also a number of benefits that the public charge rule does not apply to, will not be considered by USCIS. So let's say, for example, the public charge rule normally would apply to you, and you have to report your income, your education, and so on and so forth on Form I-944. There are a number of public benefits that you don't have to report because they're not factored in as part of the public charge test. Some of them are listed here. Unemployment insurance, for example, whether that's PUA from the federal government or unemployment from Massachusetts. If you have a small business association loan, if you have emergency Medicaid or Mass Health Limited, if you receive disaster relief after a hurricane, if you've used food pantries or a homeless shelter, if you've used WIC, Women, Infants, and Children, if you receive free school breakfast or lunch through a public school, if you receive energy assistance, for example, LIHEAP, the public charge rule does not consider the use of those benefits as part of its test. Specific to COVID-19, there are a couple things to know. USCIS has claimed that it will not apply public charge to testing, treatment, care, or an eventual vaccine related to COVID-19. Additionally, if an individual would be subject to the public charge rule, and they have to rely on a covered benefit during the pandemic, they can submit an explanation with their application as to why they had to use it. For example, for pandemic-related reasons, they were laid off from work, or they lost their childcare and had to leave their job. And USCIS will factor that explanation into their decision-making process, because remember, it's a multifactorial test, and the existence of any one factor is not exclusive or determinative. In general, also, remember that a family or household member's use of benefits will not count against you. So, for example, if I was applying for legal permanent residency and the public charge test applied to me, and I had a US citizen child who was using SNAP or who received Mass Health Medicaid, my child's use of those benefits would not be counted against me and would not have to be reported on the Form I-944. So you don't have to worry about a household or family member's use of benefits. The public charge rule is focused on what benefits you as an individual are receiving. Another thing to note is that if you have temporary protected status, you are subject to the public charge rule if and when you adjust your status to legal permanent residency. So if you have TPS and you are applying for a green card through, for example, a marriage or an employment-based relationship, the public charge rule would apply with one key distinction. USCIS will not consider your use of public benefits while in TPS status. So while the rest of the multifactorial rule would apply, age, education, English proficiency, work history, and so on and so forth, USCIS will not consider your use of public benefits while in TPS status as part of that multifactorial analysis described earlier. Some important things to note: that there is a significant distinction between the benefits that a person is eligible for if they are, for example, undocumented or in certain kinds of other statuses, and the benefits not included under the public charge rule. So you'll note that a lot of the benefits listed here that you can get if you are undocumented, emergency Medicaid, health safety net, SBA disaster relief loans, access to soup kitchens and food pantries, WIC, none of these are actually included as part of the public charge analysis. And that's actually a really good way of trying to remember what benefits are included. If a person who is undocumented could receive a benefit, then that benefit is not being considered by public charge. The public charge rule is exhaustive in what it does look at, whereas the list of benefits that are not considered is much, much larger. So I've outlined here some examples of benefits and eligibility for immigrants. So if you are an eligible non-citizen, like an asylum seeker or refugee, a legal permanent resident with some exceptions, or a citizen, there are a number of benefits that you do have access to, like unemployment or SNAP or stimulus payments or certain kinds of cash assistance. If you are undocumented, there's another list of benefits that you can receive. And there are a couple of exceptions if, for example, there's a member of your household who's an eligible non-citizen. So one of the reasons that we wanted to make sure that we had this workshop is because public charge has been in the news a lot lately because of a number of different legal challenges to the rule, which has caused a lot of confusion, especially because USCIS hasn't been great about updating its website or its forums to reflect these changes. So last fall, a number of different lawsuits were filed across the country challenging the public charge rule. While they did initially secure some injunctions, i.e. courts ruled that the rule could not go into effect because it was unlawful, eventually the Supreme Court stayed those injunctions, meaning that the rule could go into effect, which it did on February 24th, 2020. However, once the pandemic hit, advocates requested that the Supreme Court temporarily lift or modify its stay to halt the implementation of the public charge rule during the state of emergency. On April 24th, 2020, the Supreme Court denied a motion to temporarily lift or modify its stay, but noted that district courts could still consider this issue. In New York, in July, a district court in New York held the public charge rule could not be applied during the pandemic. And while that was very exciting, and there was certainly a big outcry from advocates like us, a lot of excitement, that was limited fairly quickly by the Second Circuit, which is the appellate court that sits over the Southern District of New York, just under the Supreme Court. The Second Circuit limited the injunction on the public charge rule to just 3 states, Connecticut, New York, and Vermont. What that means is the Department of Homeland Security can implement its public charge rule in all other US states and the District of Columbia. So if you are applying for a green card from a state beyond Connecticut, New York, or Vermont, like Massachusetts, the public charge rule would still be applied to your application. USCIS has not issued guidance on how it will implement these differing public charge standards. Additionally, USCIS has not updated its injunction page in order to reflect the decision by the Second Circuit. It also has not properly amended Form I-944 to reflect this. However, given the pretty unequivocal decision from the Second Circuit, we caution folks to remember that despite USCIS's failure to update its pages, the rule is still in effect for those applying from outside of those 3 states, Connecticut, New York, and Vermont. However, the important thing to note is that the rule is still being challenged. The Supreme Court's decision was limited to the injunction. Essentially, can the rule be stopped from going into effect while the case is being litigated, while the parties are fighting out the merits, potentially having a trial, bringing forth evidence, and all the rest? It is possible that ultimately, courts will decide after a trial, after a full evidentiary presentation, and all the rest, that the public charge rule still has to be stopped from coming into effect. So there is still another chance. The other thing to remember is that this is a regulation. The public charge rule is put out by the Department of Homeland Security. It's not a statute. It wasn't promulgated by Congress and signed by the president. To remove that rule, a new presidential administration potentially would need to issue just another regulation to rescind it. It could also be invalidated by courts or addressed by Congress. So the existence of this rule right now doesn't necessarily mean it would be there forever. It might be removed through other means depending on the outcome of the November election, depending on the outcome of these court cases, depending if Congress decides to take additional action. So now we're going to do a quick role play to cover a couple of different topics that we know can come up for folks who might be subject to public charge. So in particular, Jake and I are going to play the parts of a couple of different individuals. These are hypothetical situations based on real people and real questions that we've gotten or that our community partners have gotten. Jake is going to come to my office for help and I'll give him advice. Please note that immigration is very complicated, and often it's important to know the individual factors in someone's case in order to make a decision, unless we can say there's something like a categorical exemption. If you have questions, it's important to either contact an individual immigration attorney or to contact a specialized organization for advice. For example, you can always call Lawyers for Civil Rights Public Charge Hotline in English and in Spanish to get advice confidentially from an attorney about the application of public charge to your case. That number is 617-988-0609. And we'll repeat that and have that on a slide at the end of this presentation. So Jake, if you're ready, let's begin.
Good afternoon. My name is Angelo, and I was referred to Lawyers for Civil Rights through my church. My pastor told me that you guys provide legal support for people of color in Massachusetts. I'm a DACA recipient. With everything that's going on right now, I've been very confused about my DACA status renewal. I'm particularly worried about the public charge requirement that they've been talking about on TV and how that requirement could affect my renewal application.
I have good news for you. If you are a recipient of DACA, or a deferred action for childhood arrivals, and you are applying to renew your deferred action, you don't have to undergo a public charge test.
That's really good to hear. I'm also worried, though, about being able to get a healthcare plan through the state. Is it possible for me to get healthcare in Massachusetts as a DACA recipient?
So in Massachusetts, you have several healthcare options. In addition to the Health Connector, you are eligible for Mass Health Limited, also known as Emergency Medicaid, Mass Health Standard, Common Health, Family Assistance, or the Health Safety Net. You can apply for many of these online or ask for assistance at a community health center or legal services organization. Now, Angelo, is there any possibility you might apply for a green card in the future?
Possibly. I have some family members who are citizens and green card holders.
That's really good to know. If you apply for a green card through a family or employment-based petition, what we call adjusting your status, you will be subject to public charge. That means USCIS will employ a multifactorial test that looks at your age, your income, your assets, your English proficiency, your education, and your use of benefits.
Okay, I understand. But some members of my family are on SNAP, so will that count against me with the public charge test? Also, we just received our stimulus checks. So can we deposit that check? Will it affect our public charge test?
Luckily, a household member's use of benefits will not count against you for public charge purposes. The government will only look at whether you received any of the covered public benefits for your own benefit or where you were a listed beneficiary. They will not attribute receipt of benefits by members of your household to you. Lastly, the stimulus money from the federal government, if you were eligible to receive that, will not be considered by public charge.
Okay, so we are now shifting to another scenario where I've now adopted a new name. Hello, I'm Paul. My family and I have been experiencing a lot of hardship during the pandemic. My work hours have recently been reduced and we've had a lot of difficulties applying for unemployment. Between providing for my family and paying rent, I'm stretched thin. I've been unable to pay for rent for the past 2 months. Our landlord has been harassing us. He told us that if we don't pay up, he'll call immigration on us. I wasn't too worried about these threats because I was here through TPS, so they told me that the government won't do anything. But I've been hearing about this new public charge requirement. I don't know what it is, but folks have been saying it can make it harder to be an immigrant. So now I'm pretty worried. Can I still re-register for TPS? Will public charge affect my ability to re-register? And if I want to apply for a green card in the future, will public charge affect that as well?
I'm so sorry to hear that you're experiencing that, Paul. I hope I can help. If you're re-registering for TPS, you do not have to worry about public charge. That test will not be applied to your re-registration. However, if you apply for a green card from TPS, that is, if you adjust your status through a family member or an employer, the test would apply. But, very importantly, USCIS would not consider your use of benefits while in TPS. So they would still do the multifactorial test where they look at age, English proficiency, and the rest, but not look at your use of benefits.
Wow, that's so good to hear. Thank you. But even if he can't call immigration on us, I'm worried that he'll evict us if we're not able to pay the rent. I've heard of Chelsea's emergency program and also this program called Raft that they said could help us with our rent. If we apply for those programs, will that affect our public charge analysis?
I have other good news. Even if USAS was going to consider your use of benefits, neither RAFT nor the emergency programs put out by entities like the City of Chelsea are included under public charge. If you need assistance with applying for RAFT, you can call Lawyers for Civil Rights at 617-981-4308 for help in English and Spanish. Also, if you're experiencing harassment in your home, you can get help from the Attorney General's office by calling the Civil Rights Division at 617-963-2917. This is the Attorney General of Massachusetts. They're a state agency that is committed to protecting residents of the Commonwealth, and you are entitled to protection regardless of your immigration status.
Thank you so much. I'm really glad these supports are available.
Finally, remember that Massachusetts has temporarily prohibited evictions during the COVID-19 pandemic. That means in most circumstances, evictions can't be filed in court, a landlord can't terminate your tenancy or send a notice to leave the residence. The deadline to respond to or appear in court for any eviction cases has been extended until after the temporary prohibition is lifted, and constables are prohibited from removing a tenant from the property. This applies regardless of your immigration status.
Wait, you said most circumstances. So what are the circumstances where they can evict you? And if I can't pay, do I need to let my landlord know?
Evictions can only be brought if you violated the terms of your lease or engaged in criminal activity in a way that impacts others' health and safety. If you can't afford to pay rent because of a COVID-19 financial hardship, notify your landlord in writing and provide documentation within 30 days of the missed payment so the landlord can assess a late fee. If you're being unlawfully forced out of your home, call the Attorney General Consumer Hotline at 617-727-8400.
Okay. And we are now moving on to another scenario. In this one, my name will be Danny. Good afternoon. I'm Danny. I've been going through some hard times because of the pandemic. My work is closed. I'm struggling to feed my children. My brother has been telling me to apply for benefits, but I'm honestly too nervous to do so. I'm undocumented, and recently my neighbors have been talking about this thing called public charge. I honestly don't know what that is, but I heard that it will make it harder for people like me to get benefits and will affect our ability to stay here. How will the public charge affect me? Will public charge prevent me from applying for benefits?
These are really good questions. I'm going to take these one at a time. First, with regard to public charge, that rule only comes into play if you're planning on applying for a green card or extending or renewing non-immigrant status. Are you planning on applying for a green card in the next little while, say the next year?
No, but maybe in the future.
Okay, so remember that this version of the rule was put in place by the Trump administration, and it may be revoked, undone, or reworked if there is a new administration, which could happen in January. So keep that in mind.
Okay.
And second, the benefits that undocumented folks are eligible for are, as a general rule, not counted for public charge purposes, like emergency Medicaid, for example, or free school breakfast or lunch. You can also access food pantries without any problems. And remember that your household or family members' use of benefits won't count against you. So if your children are eligible for SNAP, that won't be counted against you if and when you apply for a green card.
That's very reassuring. But I got a letter recently that talks about this thing called PEBT. I don't really understand what it is, so I asked my kids to translate for me. They said it's a program that can help me feed my children. Is that true? If so, I'd like to apply, but I don't speak English very well, and I'm still worried that public charge might prevent me from applying.
Public charge does not apply to PEBT or pandemic EBT. It allows states to provide meal replacement benefits for households with children who attend a school that is closed and who would otherwise receive free or reduced price meals. Monthly benefits of up to $125 per child will be loaded onto an EBT card, and PEBT is available regardless of status.
Thank you so much. Lastly, as I said before, I got laid off. I want to apply for unemployment again, but I'm really worried about this public charge thing. What should I do?
Unemployment is not considered in public charge determinations. Unfortunately, though, if you are undocumented, you cannot get unemployment through the state or through the new program called PUA. There are various funds available for undocumented workers and families in Massachusetts. such as Mass on DocuFund or the National Domestic Workers Alliance Coronavirus Care Fund.
Okay, and so this is our last scenario, and I will be John here. Hello, my name is John. I've experienced a lot of financial hardships lately because of the virus. I drive for Lyft, and because of the pandemic, people have not been requesting rides as much. My other job at a restaurant also reduced its hours. I'm struggling to support myself and my family. I want to apply for unemployment, but since I wasn't laid off and since I drive for Lyft, I don't know if I'd qualify. Furthermore, I'm also a green card holder. I've heard recently about this thing called public charge, and I'm worried that if I apply for unemployment, I'll run into trouble with immigration. What should I do?
I'm really sorry about this situation. This is definitely something that hopefully we can help you with, but let's take this one step at a time. The federal government created a completely new program called Pandemic Unemployment Assistance to cover workers normally ineligible for normal unemployment, like independent contractors, and it covers a lot of situations where individuals are unable to work due to COVID-19. It does include people who are underemployed, like you, who've had their hours cut back because of the pandemic. For assistance with unemployment, you can contact LCR at lawyersforcivilrights.org/gethelp or by calling 617-981-4308.
That's fantastic.
Additionally, green card holders like you are eligible for unemployment. You don't need to worry about public charge for two reasons. First, unemployment is not considered in public charge determinations. And second, that test will only apply to a green card holder if they leave the US for 6 months or more, and they have to reapply for a green card when they return.
That's really great. Also, I'm worried about my kids and want them to get tested for the virus. They have mass health, but I'm worried that public charge might somehow affect that. I also don't know where to get tested or what we have to do to get tested in Somerville or in Chelsea. Do you have any information that could help?
Okay, let's talk about mass health and COVID. If you did leave the US for 6 months or more, then you would be subject to the public charge test, and it normally does consider use of mass health, i.e. Medicaid. But there are two things to note. One, USCIS will not consider the use of mass health by those under 21. Two, USCIS has been clear that it will not consider COVID-19 testing, treatment, care, or an eventual vaccine, even if obtained through Medicaid as part of public charge. There are a lot of different options for getting testing, even if you don't have COVID-19 symptoms. Some of these places require appointments, some of them allow walk-ins. For example, Beth Israel and MGH both offer testing for people who are sick or have been in contact with someone who is sick. Walk-ins are accepted, but appointments are strongly encouraged. If you're an MGH patient, you can call your PCP to make an appointment, and if you need to make an appointment with Beth Israel, you can call 617-975-6060. To be tested, you don't need to be a patient of the clinic, you don't need health insurance, and your immigration status does not matter. Okay, so that is our presentation. If folks have any questions, please feel free to reach out to myself or to Jake. We'd be happy to talk to you. You can also feel free to call our public charge hotline at 617-988-0609, where we can answer questions in English or in Spanish, or to shoot us an email at lsampson, LSAMPSON, at lawyersforcivilrights.org. But thank you all for being with us. So maybe we can stop this recording and we'll start a new one just for Spanish.